Thank you. You all may be seated. Okay.
My apologies, Judge, for running so late. Some more judges in the last 3 weeks than I ever want to. I want to just go back to my office and do my paperwork.
Okay. Everybody ready?
Yeah.
I know you're ready. You've been here for a minute. Ms. Robertson, can you give me the name of your client?
Carolyn Pena.
Have a phone call? The court goes on record in cause number 2016-3379. This is a motion for new trial between the parties of the Office of the Attorney General versus George Eric Saldana and Carolyn Pena. Counsel, please state your name for the record.
Carolyn Robertson. I represent Carolyn Pena.
George Saldana, pro se.
Thank you. This is, Donnie, will you all be presenting anything to the court other than oral arguments?
There were some exhibits that I filed with the motion, Judge.
I don't see that I was served with any exhibits, Judge.
They're on the court's file.
I can't. Okay, they're in the court's file, but you also, if there's any exhibits, you still have to abide by the rules of, except if there's opposing counsel, you have to give them the copy of the exhibits because they have to prepare. They have to have opportunity to prepare.
They were all e-filed to counsel.
Okay. Okay, Mr. Saldana, this is. Do you have them on your service, Ms. Cooper Robertson?
I'm looking at them now. He didn't serve them to me directly, but I'm pulling them up out of the court file.
It was e-filed and served, Judge. Rule 21A.
So give me just a minute, I can take a look real quick. Okay, Judge.
Mr. Saldana, this is your motion.
Yes, ma'am. Can we have some housekeeping real quick before we start?
Sure.
Yesterday was the 20th day for the findings of facts. I'd like to do an oral motion for a request of the second. I'll go ahead and still file it, but I want to put it on the court's record that the first 20 days for findings of facts did expire last night at 8 p.m. It's been 20 days. Tonight at 8 p.m. it will be 21 days. Second, there was a demand that's on file that I filed to have you report Ms. Carolyn Robertson for making statements of fact that were untrue on the court's file. I ask you to take judicial notice because I can't ensure justice if lawyers are making statements of fact that are untrue. And by the Texas judicial canon, if you want them, I brought the judicial canons if you want me to enter it into the record. The third thing is, if you need the disciplinary rules, the judicial canons, and the Texas Lawyers Creed, they're all here, Judge, if you need to see them. Okay, I'm ready to start, Judge.
You may proceed.
Yes, ma'am. Judge, as you know, November 14th, there was an unfortunate accident that happened here. And that accident went against me. And pretty much, I was arrested for assault on a peace officer with bodily injury. With that assault, I had 5 deputies jump on me. I was arrested. I went to jail for 3 days. $1,500 in bail. I was put on house arrest for 24 hours. My DNA was taken from me. I slept on the floor because there was no cots. I didn't get my meds for 3 days, and I had to ride the Greyhound home. The arrest was ultimately dismissed. And that's the basis for the motion for new trial, because my due process was significantly impacted, because I was paraded around this courthouse with 6 bailiffs when I did nothing wrong. The incident was ultimately dismissed within a month and a half, but I had to endure that. Then I had to endure shackles and come through here to go to trial because I was bench warrant back here to this court. When I was bench warranted, the state made a motion for bond conditions. And on those bond conditions, I was not supposed to have contact or any threatening behavior, harassment to the bailiffs here and the court personnel. Therefore, I could not, I couldn't let my enthusiasm run away, I would say. I couldn't litigate the way I wanted to. I was denied my books because I was under arrest. I didn't have my legal material. I was unable to prep properly. As some of y'all saw, I had bologna sandwiches. My liberty was restrained due to false allegations and I say perjurious affidavit. They put things in the affidavit so that the DA would take these charges. We had witnesses. We had my mom outside that saw the whole thing. My mom was also assaulted. Nobody would take our complaint. As you know, some of the things that we have talked about is the failure of no mechanism of reporting. We asked for supervisors to come. Nobody took a witness statement from my mom. But they hooked me up and they took me in. In one of the exhibits, and I'll get to it in just a second. I don't want to offer it just yet. We've talked about faulty affidavits in trial, where Ms. Pena had 4 variations of her affidavit, and then now we have bailiffs doing the same, restraining me. And I don't like to be oppressed. The 14th Amendment covers me from that. I should be treated equally under the law. The next issue, besides getting arrested and having my liberty taken from me, was Ms. Carolyn Robertson was out in the hallway filming the thing. And she did also state in trial to Ms. Pena, is this the type of behavior that scares you from Mr. Saldana? There was no presumption of innocence. No presumption of innocence at all. I was made to look like a cop beater, that I assaulted a cop when I was just trying to protect myself. The second issue we have is the jurisdictional issue. A motion to recuse was filed October 27th. And in that motion to recuse that you denied, I had put 2 instances where 2 other bailiffs, Stephen Alderete and the bailiff before him, had threatened me with aggression. The bailiff before Mr. Alderete threw my paperwork and threatened to arrest me while I was trying to give him paperwork. The recusal was ultimately denied after trial. They couldn't honor the recusal because we had already had trial. The denial of the recusal from Susan Brown came 12/27, 60 days later. In that recusal, the denial of the recusal, Administrative Judge Susan Brown stated that most of the things that I was complaining about were issues about the judge and the judge's rulings, which that's not true. So I don't believe this court had jurisdiction. And on the 14th of that day, I was going to go talk to Susan Brown because what was said in court was there was notice for this hearing. One of the things that we talked about was notice. And if you take judicial notice of the file, like I asked in trial, you'll notice that there is a notice of hearing, but it's not for final trial. And I would have to find it. It is for the motion it's right here. It's filed 11/8/2023, notice of court proceeding, envelope number 81419417. Notice of court proceeding. Motion to terminate community service and motion for sanctions on George Saldana to revoke suspended commitment filed by Carolyn Jean Pena, and the above caption is set to be heard November 14th through November 17th. There was no December 12th. So there's no proper, the 15th, 16th, 17th, and the 12th was never noticed to me. So therefore, I couldn't subpoena anybody. Couldn't get my subpoenas out to bring my witnesses to come testify. That's an issue. If we want justice to prevail, we have to give justice a chance. The next issue is the child support issue. You granted a motion based on Ms. Carolyn Robertson's non-suit. I pled the 5th. I was in shackles. I was in orange. I was told not to threaten or harass. I didn't want to do anything because I've already had bailiffs alter a government document with perjurious wording in it. So here, the partial non-suit came in after the judicial hearing. And I said it when I was on the stand. I didn't know nothing about a non-suit. Ms. Carolyn Robertson said it was a non-suit that she had non-suited, and it was on the record. If you look at the filing, envelope number 82818696, filed 12/21/2023, it's styled Notice of Partial Non-Suit. Again, for that enforcement action, I had representation. My representation didn't tell me there was a non-suit. There wasn't a non-suit on file. And not just that, but this is a notice of partial non-suit. So what was non-suited? I don't know what was non-suited. All I know is that Carolyn Robertson made motions and they were granted based on what she said. So the non-suit came after, the recusal came after the hearing. Again, my constitutional Fifth Amendment right was violated when I was made to answer about my medical history, which would have been my affirmative defense for child support. If you look at the notice of non-suit, partial non-suit, at the very bottom, certificate of service, it says it was served April 2nd, 2023. So the dates aren't even correct. Partial non-suit, she said non-suit, it's not filed. I have nothing known about it. I don't know about it. And then it comes after, and then I still don't even know what was non-suited. Because there's no description. What parts were non-suited? And that's where we get into the next issue of lawyer misconduct. This is not within judicial economy. Bringing me and my mom waking up at 4 o'clock in the morning to get on the road to be here on time. We've talked about Ms. Robertson making statements of fact that she knows are untrue. And Ms. Robertson stated that she gave you emails, which of course I was in shackles in Orange. I didn't get those. That's considered ex parte. I didn't get to review them. I don't know if she gave you half of the emails or she gave you all the emails. But she said it on the record. Judge, I gave you some emails. Another statement of fact that Ms. Robertson knows is untrue is that she said specifically sealed. The protective order in the 280th was sealed. And I argued it was not. I objected. I said on the record it is not sealed. I called when I got out of jail, and the record is not sealed. Is it confidential? Yes. Confidential and sealed are two different words, have two different meanings. So therefore, I couldn't even give you those records because, again, I was incarcerated for a crime that I didn't commit. No presumption of innocence. Everything that I've gotten in trouble for is based on an affidavit. We talked about it in trial. Ms. Pena stated that her attorney wrote her affidavit. That's 4 variations. That's aggravated perjury. That's aggravated perjury throughout the whole state in every court. And I know some family courts don't want to argue that, but it's within my right to make that criminal complaint. I asked the court to take judicial notice. And it's the same thing that happened when the bailiff made these comments or wrote this affidavit to get me thrown in jail. I had a $40,000 bond, and I had all those other issues that happened. You ruled 100% in Ms. Pena's favor. You gave her sole managing conservator. When she admitted to hitting me and biting me, Ms. Carolyn Robertson said it was a mischaracterization of her testimony, and I don't know how you can mischaracterize yes and no. During that testimony, I asked this court to make 3 findings of domestic violence, 3 oral motions. I still, to this day, haven't got any word on my motions. But there were actually 6 oral motions that weren't heard. There was a finding of aggravated perjury. There was a finding of fraud before the court for December 2nd, 2023. There was 3 verbal motions for findings of domestic violence. There was a finding of neglect, child neglect, for Ms. Pena carrying Christopher in the front of the car seat, or in the front of the floorboard with the airbag, violating Family Code 261. I said to make a finding of false reports to law enforcement. Texas Family Code 261.10107. And then I asked for a motion to dismiss the committed sentence. All of those went unheard, but yet the court gave 100% to Ms. Pena. There is a jury trial on file that I filed, just so that I can maybe entrust the judiciary to do the right thing and go with a jury trial this time. But the jurisdictional issue, again, is one of my main concerns. And if we have to appeal and mandamus, we will. But those are my arguments pretty much, Judge. I do want you to take judicial notice of case number 1844053-01010. In that, and I don't know if I went over this, but the state motion for bond conditions requests that the defendant have no contact with the complainant. That's a big one, a big due process issue, because I was bench warrant back here to where I was not supposed to be. I was stand to hold trial. I was supposed to be in trial, and I had Mr. Alderete looking over me, listening to my testimony, and anything I said could have been used against me. So there was no presumption that Mr. Saldana was innocent before proven guilty. This has caused a hardship, financial hardship, an emotional, mental hardship as well. My mom had to put her house up for bail. We had to come back to Houston to have this hearing. We're here on time. We're doing everything we're supposed to do for this court as per the court's rules. And we have people that are flagrantly violating them. So my next question is, how do I communicate with this court? Which dictionary do we use? Are we using laws? Are we using rules? Which laws are we using? Family Code, Penal Code, Code of Criminal Procedure? Because a protective order will hit all three of those. I asked this court to take judicial notice of the whole court file because they are affidavits, statements of fact from George Saldana in the case file, and nobody will acknowledge them. I can't get anybody to acknowledge my affidavits. Ms. Pena has 4 variations of hers, and everybody gives her everything she wants. So again, am I covered by my 14th Amendment? Because my 5th Amendment was violated. My First Amendment outside of these court doors was violated. So I'm asking this court for a motion for new trial so we can ensure justice is done properly and people can get served and we can have a real trial. And I'll rest, Judge.
Thank you, Mr. Saldana. Ms. Cook-Waddle?
Try to do this the same order he did to the best that I can, Judge. I left my file in the other court, so I'm working on envelopes here. It doesn't look real professional. With regard to the findings of fact and conclusions of law, I intend to circulate that on Monday. I have spent more time in court in the last month than I think I have in the last 3 years combined, and I am behind on paperwork. His oral reminder that findings of fact are due is duly noted. It's funny how he likes to use oral notifications, but then on September 13th, when I on the record in front of him to you in open court said that we were non-suiting our enforcement of child support, he doesn't think that counts, but he's making all of these oral motions that he expected you to go through and grant to him. When he says he doesn't get his motions heard or granted, when he doesn't get what he wants, he considers that to be a violation as opposed to accepting the results. He's asking for findings of fact that he is not entitled to. They're outside the scope of our family case here, and
I'm going to object, Judge. I want to put it on the record, 296 and 297 of the Code of Civil Procedure. Thank you.
With regard to the findings of fact that he is asking for, they are outside of the scope of this trial, and some of them that he's asking for he didn't put on any evidence, and some of them weren't made because it contradicted the evidence that was presented. Any time that he doesn't get his way, he thinks someone's lying or someone's doing something wrong, as opposed to the evidence showing that he's not entitled to what he wants. With regard to his motion against me, Mr. Saldana wants to set himself up as the arbiter of truth, whereas that is your role, Your Honor. And any time I have disagreed with him, he considers that a lie. These affidavits that he talks about filling your court file with, and the affidavits of all of his friends who come to court with him, are filled with lies. Nonetheless, our trial wasn't conducted on the basis of affidavits. The affidavit that my client filed back in August of 21 was for the purpose of obtaining a hearing date on her motion back then. He is so focused on something that wasn't evidence in this case that he forgot to pay attention to the evidence that was being presented. The weight of the evidence was so against him that he is nitpicking, trying to find one little thing that contradicts the great weight of the evidence, and he thinks that that flips everything into his favor, which is not how trials work. With regard to the 280th records, the only things that were available through HC District Clerk were the order granting the protective order and the order denying his motion to modify or vacate that. With regard to the dispute about what was or wasn't available in the 280th, he was saying that I had an obligation to know all of the evidence that he used in the protective order trial way back in 2020, I believe it was. Exhibits are not filed within the court file. He may have filed some in this case, but his attorney at the time was Elsie Martin Simon. She circulated the exhibits and gave them directly to the court, so those would not have been in the court file anyway.
I'm going to object to hearsay on that.
It's not hearsay if it was his statements.
I didn't say Elsie Simon filed that into the case.
Judge's attorney at the time of that hearing was Elsie Martin Simon. I was not involved in the case at that point. She apparently had an exhibit list and some exhibits which she would have served on the attorneys that were involved in the time, which I believe was Diane McManus and Elsie Martin Simon, and those would not have been available in the court file. What he is trying to impute to me is an obligation to have gone through all of the litigation he's ever conducted and specifically request from each of the court reporters the evidence he may or may not have used in those cases, where I'm supposed to anticipate something he might have brought up in our new trial when he had a superseding obligation to serve me with all of the evidence he would have wanted to use at that trial. If he wanted in our trial here to use evidence that he used in a 2020 protective order, it was his duty to serve me with copies of that, not to complain that I didn't anticipate something I couldn't possibly have known, and to be 7 steps ahead of him in case he changed his mind. Before his arrest, he failed to serve me with his exhibits for that trial. With regard to my non-suit, on the record, in front of a court reporter, in front of Mr. Saldana on September 13th, I non-suited that case. If Mr. Saldana does not understand that a non-suit is effective in that manner, I can't tell him, you can't tell him any more times than he was told that that was effective, and made it to where I could not have gone forward on that. It came up probably 10 times in our trial that the announcement was made in open court and that it was effective upon my announcement.
I'm sorry, how many times did you say? For clarification?
Please just say one, you guys.
I'm sorry.
Don't give, Mr. You presented your stuff in a methodical manner.
Okay.
I'm hoping Ms. Cook Robinson will do it too, the same as you do. Present your argument. Don't, and nothing other than your argument. You may continue.
Thank you, Judge. You ruled during our trial that that non-suit was effective. There was no motion for enforcement of child support that I could have gone forward with at the time of trial. He's claiming it violated his Fifth Amendment rights, but he never supplemented his discovery in violation of the Fifth Amendment rights anyway, so that is a moot point. I later did file a paper document into the file at the request of his appointed attorney so she could clean up her file. It doesn't change the fact that the non-suit was effective back on September 13th. I did have a typo in my certificate of service. He's very fond of circling my occasional typo and putting them all over Facebook, but then asking that we overlook his clerical errors. All of these are harmless errors anyway, but again, he keeps trying to direct our focus to the little teeny tiny things that don't actually affect the outcome of the case, in the hopes that that will flip the great weight of the evidence that is otherwise against him. In his motion against me, he is also claiming that I committed perjury by making a statement to you that Judge Lopez recused herself because of his Facebook page or posts. Judge Lopez did, I acknowledge.
Objection, hearsay.
Sustained.
All right. With regard to her on-the-record statement in her docket entry, it says that Facebook posts were the reason. I wasn't posting about the case. My client wasn't posting about the case.
Objection, hearsay. She said her client, she doesn't know that for sure. Her client has made fake Facebook accounts.
Stop. It wouldn't be hearsay. It would be another objection, Mr. Saldana. Just
She can continue.
within your own knowledge, Mr.
The fact that I used...
Within your personal knowledge. Just give me something in your personal knowledge.
Yes, ma'am. The fact that I used deductive logic in a statement I made before the court doesn't qualify as a lie, despite the fact that I disagree with what Mr. Saldana thinks. And again, it's not a lie just because he doesn't agree with the statement that I have made. As for the notice of hearing, there was an email exchange between Mr. Saldana, myself, and Molly May on November 6th, in which it was made clear to both of us that the hearing or the case was going to go to trial on November 8th of 2023. I then replied to both Molly, or Ms. Mai, and Mr. Saldana that I had a vacation letter on file for that date and was unavailable. And so we were then given the date of November 14th. Mr. Saldana then, and that is well within the normal procedures of the court when scheduling a pref-set hearing to get communications from the court in that manner. He got the communications because he responded to them. So him saying that he never got any notice is an actual lie as opposed to a disagreement. Then, after it was decided that we would proceed on November 14th, Molly entered that into the public computer system and reset or stated that the case was set for November 14th. There was a prior entry that we would be in the hearing 2 or 3 different days, and it says reset, and then there's a re-entry again for November 14th. So there was one on November 14th that was canceled and then it was re-entered. But the emails clarify for Mr. Saldana so that there was absolutely no doubt that we were starting trial on November 14th. He asked for a continuance from Molly so that he could subpoena witnesses and was told that that was not going to happen. He received that on November 6th, so he could have still issued subpoenas. He had more than a week prior to that. And then he proceeded to argue with probably 30 or 40 paragraphs in total that he didn't want to go to trial. It didn't change anything. He says here no notice for trial has been sent. That was sent by Ms. Mai. He was aware. I filed an additional notice, since Molly Mai's notice was for trial. I filed a separate notice of court proceeding for my motion to terminate the community supervision. He got 2 notices. He can't fall back and say that just because one notice didn't mention everything that was going to be on the docket that day, excuses him from a trial setting that he had notice of. Then we had several more emails back and forth. He's quite snarky. I did my best not to rise to the bait, but I probably said some snarky things too. I think I've shown remarkable restraint dealing with Mr. Saldana over the last year. And then he makes a lot of threats against both you and I here, and nonetheless we started trial with his having full notice. Just because he didn't want to go to trial that day doesn't mean that he was entitled to a reset. As far as the emails, when I made a statement in court that I have given you emails, Judge, that was, I believe, our Exhibit 76, which I gave to you in the form of an exhibit, and which, even though he didn't serve his exhibits on me, I duly served on him. And he had access to every single email that you, as the judge, had access to, Judge. You and I both know, and Mr. Saldana should know, that I did not commit any type of ex parte communication with this court with regard to any additional information, and the emails that I refer to are entirely contained within our exhibit. Again, I believe it was Exhibit 76, but I'm doing that from memory. I may be off on that. It was something in the 70s for sure. With regard to his complaints about having been arrested, he used the statement, "I did nothing wrong." Mr. Saldana's behavior in this court for months has been egregious. The arrest, the DA may have chosen not to go forward on that for whatever their reasons are. That does not mean he didn't commit egregious behavior. It does not mean he wasn't screaming at everyone in this courtroom. It doesn't mean that he wasn't tape recording the proceedings and then throwing that in all of our faces as he slammed his phone on the table. It doesn't mean he wasn't talking over me so that I couldn't get a word in edgewise when he kept claiming his First Amendment rights were being violated, even though he was the only one who got to talk. He is trying to say that the fact that he was wrongfully arrested affected this whole case. That was a drop in the bucket compared to all of his other behavior. And Judge, you are skilled enough as a jurist to set aside and compartmentalize information like that, and you made it very clear that you were not taking that information into account in our trial and that you were going to be making your decision based on the evidence. So if he chose to comport himself in a manner that was unflattering to himself during these proceedings, he can't blame anybody for that but himself. And if he chose to let that be the person and the parent and the litigant he showed to the court, the responsibility for that lies entirely on him. He's expecting us all to pretend his behavior was perfect and that he got a clean slate when the trial started. He mentioned I filmed the arrest in the hallway. I did. I was, in fact, concerned that someone would misstate something or claim something that hadn't happened. So I did film it in the hallway. I didn't use that as an exhibit until he said that a few minutes ago. I'm assuming you didn't even know that that was recorded, because I certainly never told you. I certainly never showed it to you. He keeps talking about the presumption of innocence. That is a proceeding that takes place in the criminal court, not here, Judge. You weren't required to find him innocent or guilty of whatever he was arrested for. We didn't have a trial about his arrest. And again, his entirety of behavior in front of you over the months certainly is of nobody's fault but his. With regard to the lack of jurisdiction, Judge, it was clearly communicated that no stay would be in place on these proceedings because it was a third recusal. That was part of the content of the emails between Mr. Saldana and Ms. Mai and myself in early November. Let's pretend, though, that you didn't have jurisdiction at that point, and that didn't become solidified until it was papered up later. That's going to be a harmless error at this point, because ultimately the recusal was denied and we would have been sent back to the same court, and the same trier of fact who was not recused would have been making the decision. He says that he was previously threatened by the bailiff, who threw paperwork at him and threatened him. Judge, I was standing about 4 feet away during that proceeding, and you were on the bench at the time. Mr. Saldana was taking his numerous affidavits where he was asking the court to file criminal charges against my client, and after our hearing, he tried to give them to Ms. Mai, who said she doesn't take in paperwork, and he took them back. He then tried to give them to the bailiff, Mr. Aldred, I'm not sure how to pronounce his last name, who said, it's not my job to take in this paperwork. So Mr. Saldana put them on the bailiff's desk and said something along the lines of, they're yours now, you have an official duty to do something with them. And the bailiff said, no, I don't, and you need to take your paperwork back. And he started saying, no, I'm not going to. So the bailiff simply pushed them off the desk, and they fell straight forward, inches in front of his desk. There was never a threat made by the bailiff. There was, despite Mr. Saldana's numerous Facebook posts about it, any threat that the bailiff was going to shoot him or arrest him. Mr. Saldana kept putting his hands out, going, cuff me if you want to. He was trying to create a scene in the courtroom, and at that point you told us all to hush up, and we did. He's trying to act like some great threat was made against him when simply people are reacting to his bad behavior and not jumping every time he says jump and not doing what he wants done. He has absolutely failed to state a single claim that he could have presented in trial, that he was denied the opportunity to present in trial, which is one of the 3 mandatory requirements of a motion for new trial. You gave him the chance to testify narrative. He ran out of time. You gave him more time. I believe it may have been twice that you extended his time, so that if there was something he left out, it was because he chose not to speak of it at that point. He complained that his motion for my client's suspended commitment be revoked and that she be placed in jail was not heard. Judge, it was heard. It was denied on due process grounds and denied with prejudice on that basis. So it was heard. He just didn't get the result that he wanted, and now he's claiming that he was denied his opportunity. Every time a litigant loses a motion doesn't mean he gets to re-urge it until he is given what he wants when he wasn't entitled to it in the first place. He's complaining that he didn't get a jury trial. My client was the one that made a jury trial request. 2 judges later, 1 judge later, we end up in front of Judge Lopez, which is about when I came into the case. I came in March of 23, and it was already set for an April bench trial. I am the one that pointed out to Mr. Saldana that we were set for a bench trial, not a jury trial. And he started arguing with me by email that I couldn't deny him a jury trial. So I told him, you need to contact the coordinator and make arrangements to get a jury trial setting. He did nothing, so I think it was a couple of days later, I followed up and emailed the coordinator, the 308, to say, Mr. Saldana believes that he wants a jury trial in this case, in which case we need to make arrangements for that. We ended up having a conference by Zoom with Judge Lopez, during which Mr. Saldana waived his right to a jury trial because he was informed that having a jury trial would delay this proceeding by months, and he said he wanted to go to trial. And that conversation was probably a good 5 minutes in which he, on several occasions, said he would like to go forward in front of the bench instead of a jury so he could get this case to trial. We then set the case for a bench trial in July. We even filed a document with the court at Judge Lopez's request. In writing, he waived his jury trial request.
Judge, it was a Rule 11, and it was just for those days in April. I didn't expect it to go to November or December. It was a Rule 11 for those specific days. And since we're not going on that, that breaks the contract of the Rule 11.
Ms. Saldana's misstatement of waiving a jury trial and the effect of that, notwithstanding, we came before you, I want to say, at the end of May 28th maybe, I think. After the case got transferred here, your court immediately issued a scheduling order. So we came here and had a bench conference in front of you, Judge, where we talked about the fact that Mr. Saldana keeps saying he wants a jury trial. I brought it up to make sure this issue was dealt with so he couldn't later claim he was denied a jury trial. I even recall on the record saying, I want to be clear, I am not
Objection,
the one,
testimony.
I am not the
She's testifying.
Overruled.
I am not the one trying to get out of a jury trial. I am fully prepared to go forward with a jury trial. I don't know if Mr. Saldana does or doesn't want one at this point, and I think we need to clarify it. We talked about scheduling, and he was again informed that if he wanted a jury trial, it would probably be well into the next calendar year. And then he, on the record, waived his right to a jury trial, and seems to think that that is something he can change his mind on 17 times because he didn't like the result in front of the judge. Waiver of a jury trial is a waiver of a jury trial for that cause number, not for each individual trial setting. And when we reset the trial, he doesn't again get to decide if he wants a jury trial or not. I believe that way back in April of 23, when we put that document into the court file saying that he did in fact knowingly waive his right to a jury trial, put that issue to bed. Nonetheless, I made sure to clarify it later, and now he is complaining that he didn't get a jury trial. His statements about what laws are we using. I mean, the trial is not law school, Judge. He chose to proceed pro se without an attorney, was required to deal with the laws as they apply. He can't later here say, we didn't inform him of every law and every book we were going to follow. I can't even remember the last time I looked at a dictionary, let alone needed clarification from a judge what dictionary he was using for a trial. Again, that's just obfuscation on his part, trying to get you to focus on the little things other than the great weight of the testimony. And then with regard to him claiming that this has been a financial hardship on him, this man laughs at how he is. Even though the legal fees are
Objection, speculation.
He emailed it to me that he thought it was funny, Judge, just so you know,
Objection,
that
speculation.
He was, I don't know if you want to rule on that objection?
Judge, if she's gonna testify,
I
sorry.
ruled on the first one she said.
Okay.
When she responded, you emailed her saying stuff. that would not be speculation. If she said she received an email, that would be her first-hand knowledge. But I will sustain you
Judge-
first.
Okay, yeah, just, I mean, she can either be an attorney or a witness, and if she's going to be a witness, I'd like to cross-examine her. If she's going to
Okay, so-
if she's going to testify to things,
So I'm giving both parties the opportunity to say their
okay,
or argument, which you stated some things that would have been classified as argument, as
Argument.
testifying also. And in this case, you are representing yourself as a pro se party, which puts you in your, not a real licensed attorney, but in a position as your attorney for yourself. You may.
He has taken great pleasure in driving up Ms. Pena's legal fees, and the only person who has committed a financial hardship, or has incurred a financial hardship in this case, is Ms. Pena. She has incurred tens of thousands of dollars in legal fees, which have unfortunately been inflated based on Mr. Saldana's behavior during this lawsuit, which took me more time than I would normally have to spend on certain things. I believe I have addressed all of the points that he has brought up, Your Honor, but I certainly see that there is no reason to file any type of a grievance against me. He's done that already, and it's been denied. He took it up on appeal, it was denied. If he wants to file another grievance, he's more than willing to, or more than able to do that. I will deal with it at each occasion on which he may choose to do so. His motion for new trial, again, everything that he complains of was his own fault. He can't have unclean hands and then claim that we need to wash his hands for him in retrospect and undo his own behavior. There is no defense, he's even stated within his motion, no claim or defense that he was prevented from asserting at trial that would have a reasonable effect of, or, I'm sorry, be reasonably expected to affect the outcome of the case. The fact that you ruled against Mr. Saldana on almost every issue in this case is not evidence of corruption or a lack of evidence or something that went wrong. It is simply the logical conclusion that a jurist would draw at the end of a trial, having heard the 2.5 days worth of evidence that was presented to you. If the weight of the evidence was against Mr. Saldana, that doesn't mean that you did something wrong or that he gets to keep trying until he convinces somebody that the great weight of the evidence is meaningless. I would ask that you deny each of his motions and that we move forward with the appeal if that's what he intends his next step to be.
Judge, if I may comment on a few of those things.
You may.
Okay, Judge. First off, I want to talk about the 280th. It's her duty to investigate her client. If she knows that her client has used protective orders, it would have behooved her to investigate the 280th court and ask for those documents or sign into the case as part of Ms. Pena's representation. Again, there is one thing Ms. Simon told me is that she's a musician.
Objection, hearsay.
All right.
Sustained.
Why do we have the rules of civil procedure? We have them to set a baseline for us. And one of the things, or I'll just tell you, legislative intent is how the law is written. There's plenty of case law for that. And so we go for word. So if you look up 21, Rule 21A, every plea, motion, or application of the court for an order, whether in the form of a motion, plea, or other form of request, unless presented during a hearing or a trial, must be filed with the clerk of the court. An email isn't filed with the clerk of the court. So the recusal email, when you recuse, and again, it goes back into where do I believe if there was ex parte communication. You and Ms. Robertson stated that y'all had gotten notice about the administrative judge saying it could commence, and then someone brought up tertiary. And nobody, I hadn't brought up tertiary, but somebody, but seems like somebody was in cahoots with the word tertiary. Yes, ma'am.
I brought up tertiary.
Okay, so, and I have a right to respond to that. I have a right to respond to that. But when people are making notices and they're not filing them with the court, what do we have the civil rules of procedure for? I mean, it clearly states it should be filed with the clerk of the court, so everybody has notice. A court must publish the information needed for participants to participate in its proceedings, is what Rule 21 says. Now, my son is at stake. I've been doing this for 7 years. I'm from the streets. I didn't go to law school. I'm doing this, I'm learning all of this by myself. And the unorthodox ways that I litigate is within my First Amendment right. Legislative intent is how the law is written. Now, I want to bring up Texas Government Code, section 53.051. Bailiffs for family district courts in Harris County. Office of the bailiff. The judges of the 245th, 246th, 247th, 257th, 308th, 309th, 310th, 11th, 12th family district courts shall appoint a person to serve as their respective courts as bailiffs. A bailiff is an officer of the court and performs the duties of the office under the direction of the supervision of the judge of the court. Unwritten, and it says, if you go back down to duties, 53.057, a bailiff shall perform the duties imposed on the bailiff under general law of this state and the duties required by the judge of the court served. Now, general law, aggravated perjury, this bailiff has just witnessed perjury. I have a right to file that criminal complaint. It's unorthodox, it doesn't happen, but he's still a bailiff with Harris County, and his policies and procedures still say he has to uphold general law. Not just his policies and procedures, but the government code does. So we get into jurisdiction of the courts. Judge, you're sitting up here on this bench because the Texas Constitution allows you. You have to meet certain requirements. You have to have so many years as a practicing attorney. And so you go to Article 5, Section 1 of the Texas Constitution. The judicial power of the state shall be vested in one Supreme Court, one Court of Appeals, in courts of appeals, and in district courts, in county courts, in commissioners' courts, and courts of justice of the peace, and such on. So, you come back to Section 8, Article 5, Judicial Department of the Texas Constitution, jurisdiction of district courts. District court jurisdiction consists of exclusive, appellate, and original jurisdiction of all actions. You have exclusive jurisdiction over the court order that was violated by Ms. Pena. I tried to subpoena Precinct 4 to come testify, and those were quashed. I can't get offense reports for interference with child custody. Retention in violation of a court order or judgment is in the penal code. It is a state jail felony. Just because this court is a family civil court does not mean it can still neglect to enforce or uphold its exclusive jurisdiction court order. If I can't get it out on the streets because an officer won't give it to me, a supervisor won't give it to me, I have no other choice but to report it to you by filing it with the court. Now, how do I file an affidavit? Code of Criminal Procedure, Chapter 15 and 45 goes over how to file a criminal complaint affidavit, what it must consist of, what it must say. I am well within my right. If you go into Texas Family Code, Definitions, section 71, court. Court meaning district court. This is a district court. I went and tracked down the rules that were signed by the Supreme Court for y'all to operate as family courts. While you do preferentially take family cases, I tried to tell you that Ex parte Clear, Houston, 1978, you are still a magistrate of this county. You have magistratal powers. That's what gives you writs. That's what you're able to do warrants and citations and stuff, because you have that power. Again, one of my big issues is there's no mechanism of reporting. This is something that we have dealt with for years. So my frustration is warranted. This is my child. I am trying to make criminal complaints. I am trying, and you might not like my behavior, but my behavior is not illegal. Everything I did was legal. Now, she can say that I was loud in the court. I do have hearing loss. I was a fireman. I sat next to the siren. I talk loud. Does it mean I'm unruly? I know what the legal definition of decorum is. I looked it up so I can tiptoe to that line to progress my case. I understand that they don't think that this is lawful conduct, but it's unorthodox litigation, and this is the type I've had to do to get from point A to point B to see Christopher. Now, the Rule 11 agreement, waiver of jury trial, pursuant to Texas Rule and Civil Procedure 11, the party agrees as follows. Our agreement, petitioner waives and withdraws her request for jury trial. Respondent no longer relies on petitioner's request for jury trial and waives his subsequent request for jury trial. Both parties consent. All issues will be tried in the court. The parties announce 6-day time estimate. She asked for 3 days. I asked for 3 days. We agreed to 6 days and we got shortened. So again, the Rule 11 is not in effect. Again, the recusal, when a recusal is in, this court doesn't have jurisdiction until the administrative judge either has a hearing or signs off on it. We could have had that trial had she had signed off on the recusal before the 14th or the 15th. But again, Ms. Mai's email doesn't certify and meet the Civil Rules of Procedure 21. You can't tell me and expect me to believe everything that I've read and I've looked through, that people can be sloppy with their work. I'm sloppy because I'm pro se. If I'm a 30-year board certified attorney charging $400 an hour, I wouldn't, as a client, I wouldn't want those mistakes, those dates wrong. When she interjects words, that was the first issue we had with Ms. Robertson, and I told you, Judge, I said she's making statements of fact that she knows are untrue because she's adding words, just like she said. Well, I know I didn't do it. I know my client didn't do it, so it had to be him, so I'm going to muddy the well or muddy the waters by telling Judge that it was Dad's fault. And at the end of the day, my affidavits conform to state law. They're filed in this case. And as per Ex parte Clear 1978, you are a magistrate and you can refer my criminal complaints for prosecution. A lot of people told me I'm wrong on a lot of things. Interference with child custody. I had to go to the Capitol to work this hard. I don't play lawyer games. I don't play lawyer lingo or terminology. Legislative intent is how the word's written, how the law is written, word for word. There's no opinions. There's no sidebars. It's word for word. The recusal, the notice, all of that stuff was not filed into the case. The non-partial was not filed in the case. I'm sorry, not the non-partial. The non-suit partial non-suit was not filed into the case. And again, I had representation. My representation should have notified me. She should have been here. I could have asked her, because those medical records were part of my affirmative defense for the child support action. Thank you, Judge.
Thank you, I've heard everybody's arguments. Mr. Zanam gets the last word. Court will take this under advisement. You all are excused.
Thank you.
Thank you, Judge.